Pleased to welcome back to our law school Deborah Enix-Ross. She's immediate past president of the American Bar Association and currently serves as a senior advisor to the International Dispute Resolution Group of Debevoise and Plimpton in New York. Ms. Enix-Ross served as chair of the ABA's Policymaking House of Delegates and as chair of the ABA Center for Human Rights. As chair of the ABA International Law Section, she co-founded the Women's Interest Network and worked with the International Bar Association to create its Women's Interest Group. Ms. Enix-Ross also led an international legal exchange delegation to Liberia, Sierra Leone, and Ghana, where she delivered an address commemorating the country's 50th anniversary of independence. There are many career highlights. I'm not going to name them all, but they include service in senior leadership roles with the World Intellectual Property Organization, Arbitration and Mediation Center in Geneva, Price Waterhouse, and the International Chamber of Commerce International Court of Arbitration. Deborah was appointed by the U.S. Departments of Commerce and State as one of the original 8 U.S. members of the Trilateral NAFTA Advisory Committee on Private Commercial Disputes. It's no surprise, in light of such accomplishments, that she was named on the 2022 Forbes 50 over 50 impact list for being a, quote, change maker who uses her empathy, insight, and savvy to make the world a better, more equitable place. Welcome, Deborah.
Thank you for that very kind introduction. Whenever I hear the Forbes 50 over 50 accolade, I have mixed feelings about it because, obviously it's a great honor to be on a Forbes list, but then they put your actual age next to your bio, and it's not like I don't know how old I am, but there's something about seeing it in print that's a little shocking. It makes me think, who's that old lady? Certainly not me. But thank you for this opportunity to be with you. I am, as has been indicated, the immediate past president of the ABA. I like to tell people that next to mom, the best title in the world is immediate past, because you get what I call the R and R. You get the recognition without the responsibility. So in that capacity and with that understanding, I'd like to just spend a few moments with you talking about civility and talking about how we educate the next generation of lawyers. That's what you're doing, and how we in the ABA can be a partner with you, and dare I say, in my day job, how law firms and legal practitioners can also be a part of that discussion, because I think it will take all of us to achieve that. So when U.S. Supreme Court Justice Elena Kagan was in her 2010 confirmation hearing, she said, and I'm quoting, "What I've learned most is that no one has a monopoly on truth or wisdom. I've learned that we make progress by listening to each other across every apparent political or ideological divide." That was in 2010. So where are we now, 13 years later? Well, a lot certainly has happened, including we've elected 2 presidents. We saw the establishment of the Me Too and Black Lives Matter movement. We even witnessed a royal wedding. I'll let you think about which one. We experienced a global pandemic and the events of January 6th. Now, I deliberately use the word events of January 6th because there's not agreement on how to describe what happened that day. Some would say it was a protest that went too far, or was it an insurrection? And there lies one of our problems, how we even come to common ground. We do know that approximately 160 people have pled guilty to felonies, and another 434 have pled guilty to misdemeanors. And a total of 68 of those who pled guilty to felonies have pled guilty to federal charges of assaulting law enforcement officers. So, without a doubt, civility has suffered over the last decade. But if you need proof, according to the ABA 2023 survey of civic literacy, 85% of respondents believe civility is worse today compared to 10 years ago. And when you ask, we dig in and what are the leading causes, they cited are social media, media in general, and public officials. And then in the Gallup poll in 2023, Americans reported that confidence in institutions fell to 26%, and that's the lowest since the Gallup started measuring in 1973. But there's hope. There is hope. And for me, that's important because I'm always a glass half full kind of girl. So there is hope. That same ABA Civic Survey found that 79% of respondents want government and leaders to work together towards compromise. So, I think it is especially important for the legal profession to promote and accept diverse viewpoints as it works to bridge this polarization and erosion of trust in our democratic institutions. But to achieve this will require those of us in the legal profession to model generosity in our thoughts and our behaviors as we respect the views beyond those that give us immediate comfort and self-assurance. Now, I just want to be clear. This does not mean that we need to agree with each other all the time. As Martin Luther King Jr. said, true peace is not the absence of tension, but the presence of justice. And I can tell you, as a mediator, I can assure you that the negotiating table is not known for its absence of tension. But compromise can be achieved. My legal training, especially my involvement in the ABA, it's shown me the value that lawyers offer. It's our careful consideration of issues rooted in the law and our deliberative approach. When legal professionals actively listen, it takes a real determination to listen to someone with whom you disagree. Actively listen. But when we do that, it will allow diverse voices to come through, and our capacity for critical analysis and decision-making will be strengthened. A diverse legal profession, and not just ethnic and gender diversity, but true diversity of thought, ensures various perspectives are brought to the table. So by engaging in robust debate, we challenge our own biases and sharpen our arguments. I think these are some of the things that you discussed earlier this morning. So promoting diverse viewpoints within the legal profession starts right here with our educational institutions. Law schools have to prioritize inclusive learning environments that encourage disparate perspectives. Students have to engage in respectful discourse, and they have to feel free to challenge conventional wisdom. Aspiring lawyers exposed to these skills will be equipped with the tools needed to become effective advocates for justice in a diverse and evolving society. I know earlier today you talked about 3 C's: courage, conviction, and control. As ABA president, I also talked about 3 C's: civics, civility, and collaboration. Civility and compromise have to be cultivated in law schools if we're going to restore faith in our democracy among young people in particular. and we desperately need to restore faith in our democracy and in our judiciary. Americans are really divided over many issues, and these divisions have really roiled our politics. We know that faith in institutions is eroding, and there's a growing distrust of one another. And debates too often do not produce fruitful disagreements, but rather heated exchanges and pointless clashes. And if you saw yesterday, even the possibility of a mixed martial art wrestling in the Senate. The situation is really made worse by these great political polarization among partisan lines. So it has led to attacks on our judicial system and the norms of our democracy and the rule of law. And just as troubling is the lack of confidence Americans have in our courts. According to the ABA 2022 Civic Survey, 52% of respondents agreed with this statement, quote, "The justice system has racial bias built into its rules." 52% believe that. But among young people, and this is really for me very stark, among young people aged 18 to 36, 63% said that there was racial bias. These are the young people that we want and expect to go to law school and be a part of the legal profession. And 63% of them believe that there's racial bias built into the judicial system. Black people continue to see racial bias at a higher level than other groups, while less than 48% of white people see racial bias. 54% of Hispanics see racial bias, and 75%, 75% of Black people responded that there's racial bias in the system. Now, when I talk about these stats to my non-lawyer friends who are Black, they say to me, so who are the 25% that don't believe that there's racial bias built into the system? But that's how serious it is. So we have work to do, not only to restore that confidence, because we know our legal system is built on the foundation of debate, negotiation, and consensus building. And as lawyers, whether we're in the courtroom, whether we're in mediation, or whether we're in arbitration, or at the negotiating table, we have to model the behavior we wish to see in our communities. So as I said, when I was ABA president, we had a Cornerstones of Democracy Commission that is still going on, focused on civics, civility, and collaboration. Because what I realized as coming into the ABA presidency is my non-lawyer friends were asking me questions, and I don't know about you all, but when you have friends who know that you're a lawyer and they're not lawyers, they think that you know every area of the law. Right, so they asked me landlord-tenant, they asked me criminal law, constitutional law, contract law, every area of the law. But what I was recognizing is that the questions that they were asking were really rule of law questions. They were really questions about how our democracy is supposed to work. And so that is why we've been focused on the civics and the civility and the collaboration. And going back, remember when I talked about what are some of the reasons why civility has declined? The number one reason is social media. The second is media. Your students, our students, are students of a social media generation. That is where they grew up, that is how they grew up, that is how they learn. And remember, with social media, there's an echo chamber because you can self-select what you want to hear, what views you want to be exposed to. And you don't have to be comfortable with other views because I don't know what, I'm not on social media, so I don't know what you do on Facebook. You block them or swipe or whatever it is. You do, but you don't have to have it. The closest that I can say that experience is in my car when the first time I got like Sirius radio, and I realized that I could only play the soul music station, and my whole world was just all the songs that I knew over and over and over again. And when you go back to listening to regular radio, I was like, but they're not playing Motown. Well, because Motown happened, you know, hate to say it, 60 years ago, but it's that self-selection. And that is what's happening for our students as they're coming in. And I will tell you that as I visited many law schools as ABA president, and I made it a mission to visit law schools and speak to law students, especially, I will say, as a point of pride, the 6 HBCU, historically black colleges and universities that have law schools. But whether it was there, whether it was anywhere in the world, what I found is that today's law students are thoughtful, they're engaged, they're critical, they are suspicious, they are impatient, and they are eager to make a difference. And we have got to be able to engage them in proper ways to help them understand why it's important to get out of the echo chambers, to accommodate views that are different from theirs, uncomfortable for them even. And as someone who's in the legal profession, I will tell you that shows up for us in the workplace. And we are seeing, certainly not in my firm, but we're seeing the lack of civility or the lack of understanding how you have to accommodate different views. And it has been exacerbated, I think, because of the pandemic, where people have not been in offices or around one another in ways to help them engage. So it will be critical work. It's as important as teaching constitutional law and civil procedure and contracts law and torts. I'm trying to remember everything I took in my first year of law school. It's as foundational as everything that you teach in the first year of law school. If we do not teach our students, show them, guide them on how they have to accommodate and understand and become better lawyers because they are exposed to diverse points of view, then they're going to suffer when they come into the real world and when they come into practice. And we will be doing them a disservice. So I think we need to help guide them to use their talents to maintain and improve our democracy, which, despite its many flaws, and there are flaws, and despite its challenges, I still think it's the best guarantor of freedom that our world has seen. So achieving this, helping them to do this, is going to involve a commitment to listen to others' perspectives without rancor and a willingness to compromise. Saving our democracy might require us to agree to disagree. And with that, I thank you for the time that you've given me, and I'm happy to engage in any dialogue. This is a little scary when the law professors start to question you. I have flashbacks to the first year, but let's see how I do.
You can all just wait Cheryl Sharp or our students here will bring you the microphones and I'll hear your questions. So just raise your hand, Cheryl.
Thank you so much for your leadership and for your remarks. What is your perspective on recent initiatives by federal judges and by law firms to say they would decline to hire students who had engaged in various exercises of free speech, or some would say exercises of suppressing other people's free speech?
So even though I'm immediate past president at speaking for the ABA, one of the things we have is we must have policy in order to have an ABA position. Obviously, this is so new that there isn't an ABA policy that would address some of the actions that we've seen. You do know, of course, that the ABA is now thinking about a code or about requiring schools to have free speech policies. And I think that will go a long way in helping students understand where are the bright lines and help them to understand, what are the consequences of speech. Because one of the things I think someone talked about today, we wish we'd stop saying free speech. What I wish is that we stop saying free speech doesn't mean speech without consequences. And I think that tends to be the idea is people stand up and say, well, I have a right to say it's free speech, I have free speech. But we all know, especially our constitutional law scholars, you can't yell, just like you can't yell fire in a crowded theater because there are limitations. We need to make sure that we are at least indicating what those expectations are and what those limitations are, so people can then decide how they're going to govern themselves. So unfortunately, I can't speak directly to that situation because the ABA doesn't have policy, but there are things that we're trying to do within the association to accommodate the idea that we can have speech with civility.
My question is, I guess, drawing from your experience as either the past president of the ABA or your time negotiator or in any other setting where you had to take this leadership role. My understanding of why people go to social media or they kind of silo themselves in these things is because they seem to equate the idea of I'm heard when I get at least a significant amount of what I want. And I think your part of negotiation is hey, we have to reach a compromise. Not everyone's going to get what they get. Drawing on your experience, how have you been able to bridge that divide such that people feel that they're heard so they can sufficiently express themselves, but at the same time understand okay, you're heard, but doesn't necessarily mean you're getting everything you want?
Yeah, that's a great question because I think a lot of times when people say, I have a right to be heard, what they're saying is, and therefore you must adopt what I'm saying. And I see this whether it is at work or in other groups that I'm in. People will stand up and say, well, I have a right to be heard. Yes, I heard you. I disagree with you. And now these are the consequences, or these are the steps that we're taking. That requires trust. That requires people feeling that you're not just giving lip service to saying, I hear you, but going back to that active listening. For lawyers, it's not all lawyers, but for a lot of times, we are formulating the argument while the person is talking, right? So you can't be listening if the minute I stop speaking, you're coming back with your argument. And so what I try to tell students in particular, there will be times when something will challenge you or upset you personally, but you have to separate, as a lawyer, separate what is personal from what is best in your client's best interest. And if we do that, I think that will help us go a long way towards resolving disputes, whether it's litigation or arbitration, mediation, whatever it might be. But when you talk about having people accept that you've heard them, that requires trust. And it requires you demonstrating that you heard it. One of the best technique I've heard, I know many of you know Bob Manukin, and he does mediation where he doesn't have the parties in separate rooms. That philosophy is that you each know your case, your strengths and weaknesses, so whatever you say, let's just say it out together. And then he will mirror or repeat what he's heard. Now, repeating what you said to me doesn't mean I agree with you. It just means that I heard what you said. And sometimes when you listen and you repeat it, there might be something in there that you hadn't thought about or hadn't considered. So I think it's really about building trust and not wanting to be so determined that I'm going to get my point of view across that you're not actively listening.
we do with the problem of, it seems to me a lot of law students come in with an idea that there are so many questions that are already settled. This topic is a foregone conclusion. These are, and instead of there being another side, that this is a settled issue, and there's a right side and a wrong side to this, and so there's nothing much to learn here. Just show me the process by which I can go out now and do what I'm going to do, right? So that kind of thing is a new phenomenon, and that there is another side that has to be heard when so much is telling them, look, there is a right side to this. I want to be on it. This is a settled issue. This is like, we know gravity now. We know Newtonian physics. These things are done. These are settled. We don't have to engage these things anymore.
Yeah, so I think if we've learned anything from the last Supreme Court cases, is there's no such thing as everything that settled is settled is settled. So that's number one. Without talking about how I feel about any of the cases, looking anew and looking afresh at cases, I think, is really an important skill. When I went to law school, I remember I actually started out thinking I was going to be a First Amendment lawyer, surprisingly, because I had been a journalism major in undergraduate as my degree. And when I interned at a television station, I noticed that the women reporters that were getting the best assignments looked a certain way and were a little friendly with the station manager. This is before Me Too, etc. So I said, I'm going to go to law school and become a First Amendment lawyer. I took constitutional law. Now I think that I was an immature law student. I mean, although I was, I guess I was about 21 years old when I went into law school, 22. I didn't have the maturity that I see some of the students today, and this is the way it turned up for me. When I studied constitutional law and realized that the argument to abolish slavery was an interstate commerce clause argument and not that it's morally wrong and morally reprehensible, and that's how we won the day. I really struggled with that and decided, okay, this is not the area of law for me. If I were more mature, what I would have said is how clever were those lawyers that they were able to take an area of the Constitution where on its face doesn't appear to have anything to do with slavery and use it to abolish slavery. And so that is when you talk about them coming in and thinking, well, the law is settled on this, I don't really need to know. Explaining it in those ways, how we expand and contrast in the law, is a skill that all of us need to learn and need to keep in mind, and they especially. So that's, I think, how I would approach it, that even though you think this is settled, we also thought other cases were settled, and down the line we see how society has evolved, how the law has evolved. So you need to be able to understand how that may happen in this particular area. Well, I really appreciate the opportunity. It's a little nerve-wracking to be in front of the professors, but thank you very much.